Welcome to the third podcast for this week. So there are really three types of liquidation. The first, which we don't talk about in this unit, is liquidation by ASIC of abandoned companies. Then we have compulsory, also known as court-ordered liquidation on the grounds of insolvency. And then the third is voluntary liquidation, which is where the company puts itself into liquidation. Okay, so in the last podcast, we looked at compulsory liquidation and when there's a creditor who wants the company to be wound up. So how do they do that? We learnt that they need to establish insolvency, or they can try to rely on a presumption of insolvency. And one of those presumptions is where the debtor company doesn't comply with the statutory demand. Let's now look specifically at voluntary liquidation, so also known as voluntary winding up. So there are two types of voluntary winding up. First, where the company is solvent, so it's able, as we've learnt, to pay its debts when they fall due. And the other is where the company is insolvent, and recall section 95 A of the Corporations Act. Where the company is solvent, it's referred to as a member's winding up. And if the company is insolvent, it's called a creditor's voluntary winding up. Both of these types need to be commenced in the usual way, so a resolution of the members. So let's talk briefly about the members' voluntary winding up. Remember that we use the terms liquidation and winding up interchangeably. There needs to be a special resolution of the members to wind up the company. So remember the definition of special resolutions contained in section 9, isn't it, of the Corporations Act. And remember that a special resolution requires that 75% of the members vote in favour. Required by section 491 of the Corporations Act. Section 494, subsection 1, also requires that the directors make a declaration that the company is solvent. That is, that they've made an inquiry into the financial affairs of the company and have formed the opinion that the company will be able to pay its debts in full within a period of 12 months after the commencement of the winding up. So please go and have a look at section 491 and also section 494 subsection 1. If the directors can make that declaration, then they can proceed with a member's voluntary winding up. And remember, we also need that special resolution that I've just talked about. If the company does pass the special resolution, the general meeting must also appoint a liquidator to carry out that liquidation process. It can happen that once a liquidator has been appointed, they have a different view about the solvency of the company compared to the directors. So for example, the liquidator might decide that assets are not going to be realised in the way that the directors thought they might. So if the liquidator does form the view that the company is in fact insolvent after the commencement of a member's voluntary liquidation, then the liquidator under section 496 has a number of choices. And it's those last three on the PowerPoint. So the liquidator must either apply under section 459 B for the company to be wound up in insolvency, or appoint an administrator under section 436 B, or convene a meeting of the company's creditors, and then the winding up may become a creditor's voluntary winding up. Now, regarding a creditor's voluntary winding up, so that last point on the previous PowerPoint, it can start in a few ways. So one way is that if the directors want to wind up the company, but they cannot make that declaration of solvency. So if the directors want to wind up the company but know that it won't be able to pay all of its debts when they can, when due, they can commence the liquidation as a creditor's voluntary liquidation. See section 497 of the Corporations Act. And when you look at that section, it provides details about information about the company's affairs. And it gives some time frames as well. So, for example, subsection 1 says the liquidator of a company must, within 10 business days after the day of the meeting of the company at which the resolution for a voluntary winding up is passed, send to each of the creditors a summary of the affairs of the company, a list setting out the names of all the creditors, etc. Subsection 4 of section 497 says within 5 business days after the day of the meeting of the company at which that special resolution for voluntary winding up is passed, the directors of the company must give the liquidator a report. Okay, so please go and have a look at that section. Now, another way a creditor's voluntary winding up can occur is out of voluntary administration, which we spoke about last week. So remember that during the administration period, the creditors will need to decide, so cast your minds back to last week, the creditors will need to decide if they will keep the company going or if the company will be wound up. So if we have a section 439 capital A, meeting of creditors, which we talked about last week, and under section 439 capital C, paragraph C, the creditors resolve to wind up the company, or a company under administration contravenes section 444 capital B, subsection 2, i.e. by failing to execute a DOCA, a deed of company arrangement, that was approved by its creditors, or section 445 capital E, the company's creditors resolve to terminate a DOCA and resolve that the company be wound up, then see section 446 capital A. The administrator can become the liquidator, and then section 499 A capital, 2 capital A, so section 499 subsection 2 capital A, the creditors may at that meeting appoint a liquidator, or the administrator can be appointed as the liquidator for the creditor's voluntary winding up. Now, I know that's all quite complex, so please rewind the podcast and listen to that again if needed. So the third way is stemming from the members' voluntary winding up, which I've just mentioned. Okay, and that's the last point on your PowerPoint here. The liquidator appointed by the company after that declaration of insolvency, if we had a members' voluntary winding up, could form the opinion that the company is in fact insolvent, even though the directors made that declaration of solvency. Then the liquidator can convene a meeting of the company's creditors. Okay, and then we have a creditor's voluntary winding up. See section 496, subsection 1, paragraph C. I know all of this is quite complex, so just take your time listening to this podcast and looking at the sections that I've referred you to.